Thank you for joining us for our Children's Law Center Pro Bono training on housing conditions. My name is Jen Massey. I'm the Pro Bono Director at Children's Law Center. I'm going to briefly go through a couple of points about our Pro Bono program at CLC, talk about the virtual training series that we've been holding, as well as a few notes about today's training and where you can find on-demand resources to support you. Children's Law Center fights so each child in DC can grow up with a loving family, good health, and a quality education. We partner with hundreds of pro bono attorneys in order to serve over 5,000 children and families each year. Our pro bono cases fall in the areas of family, health, and education. We're here today to talk about the work regarding health, our housing conditions cases. You're going to hear a lot today about the work that we're doing representing parents and caregivers who are living in homes with housing conditions that are ultimately impacting the family's health and the work that needs to be done to repair those conditions and improve the family's health. We are supporting pro bono attorneys taking on our cases by screening the legal issues involved in the case to make a good match for achieving a successful outcome for the client. We're providing trainings and have different manuals and other resources so that you don't have to invent the wheel. And then we provide mentoring. So when you take on a case with us, you'll have a Children's Law Center mentor assigned to you to talk through initial case recommendations and ultimately strategize and brainstorm throughout the duration of the case. Our virtual training series has been covering all of the areas of work. So you might be watching this on demand as we've been recording these sessions, or you might be with us live today. We have broken down the different areas of work and created different sections to cover the overall content area. Today's training for housing conditions, we are for an hour and a half. This is a longer session to cover everything that we are discussing for housing conditions. And then we had a separate cultural humility training, which is available on demand on our website to support all of the work that we're doing. Our goal to provide culturally humble representation for our clients, no matter the practice area. Today's training, again, we're focusing on housing conditions. You're going to hear a lot of acronyms today. You're going to get into things like mold law, housing conditions court, how we're working with clients and handling a housing conditions case. So you're going to get a lot of material, and these materials are available for you to reference back to on our website. So you can certainly check on them when you are doing a case with us, or if you're already working with us on a case, can review back. We are handling these cases remotely. We've been monitoring the court. We've been working with our clients just to determine what does remote advocacy look like during the pandemic. So we will touch on that today. We have been doing these cases remotely. We've been thoughtful working with clients to see what repairs they may want to work on during this time. And again, the mentoring support that we offer is available to provide guidance for this piece of the work, in addition to the law practice, etc. If you have questions and you're watching this live, feel free to use the Zoom chat feature. You can also send an email at any time during or after the training. And if you're watching this on demand, please don't hesitate to send questions. We welcome them, and I'd be happy to answer them. Our on-demand resources that I've mentioned, so our materials, our videos, manuals, you can find them on our website. If you go to childrenslawcenter.org, you'll see Pro Bono at the bottom of the page. If you click there, you'll get to this landing page, and you'll see that there are various resources available on the right-hand side that you can click on. If you're interested in a case, please don't hesitate to reach out. I am happy to talk through any questions that you might have in finding a good fit and what would be successful for the client. We do ask for feedback about our training. So thinking about virtual training and feedback that you might offer in that regard, as well as the overall content and organization of material, please go ahead and let us know where we can improve and what's working for you. We are here to support you with this sort of training support. Without further ado, you're going to see two of my colleagues who are CLC mentors, and we are going to hear from both of them today. Kathy and Evan are going to discuss all of the topics that I've mentioned. I'm going to stop sharing my screen so that I can turn it over to Kathy, who's going to head us off, a senior supervisor at CLC, and again, one of our mentors. Thank you so much, Kathy.
Sorry, after 6 months, I should know how to come off mute, and yet somehow I don't. All right, there we go. Thank you, Jen, and thank you everybody for joining today. I'm delighted to be here. As Jen mentioned, I am a senior supervising attorney with Healthy Together, our medical legal partnership, and I'm joined today by Evan Cass. I'm going to start by talking just a little bit of background so you understand the context for these cases before we get into the law and how to handle them. First, I just want to thank you guys for joining us virtually, and also to acknowledge it's super weird to be speaking to you guys through a computer with no people in front of me. So I'm going to try to keep the energy up as a trainer and keep it going as a trainer. And to thank you for joining. Also to do a last minute laptop switch so I don't have my fancy background like I usually do. So I want to first talk about just a little context about the barriers to healthy housing in DC so you can understand that and sort of understand how we got into this work and where we're coming from in giving you these cases and where our clients are coming from in terms of healthy housing in DC. Because CLC approaches these cases with a little bit of a different lens than a lot of the other legal services providers may approach them. So this is kind of like the word cloud we put together of where we see all of our housing cases and where we get a lot of our housing work. So healthy housing is really the core of it. We're not necessarily approaching it from a eviction lens. We're not necessarily approaching it from just looking at the housing authority or just looking at affordable housing, though all of those are key things. Because we are a medical legal partnership, really thinking about how we can provide safe, affordable, and healthy housing for our clients, and trying to think about how we can make our clients have healthier housing through our housing conditions work. When we think about healthy housing in the city, we think about a few major barriers. The first one is really the age of the housing in the city. The housing stock in DC is a lot of it of similar age, and it's quite old. The majority of housing in DC is built before 1978, which is a magic year because in 1978, we stopped using lead-based paint. So we have a lot of housing stock that has lead paint in it, and we know that. And a lot of the housing is substantially older than 1978. The reason that I flag the age of housing is that means a lot of housing needs major capital repairs. So they need all of the pipes replaced. They need the roofs replaced. They need work on the outside of the building. My house that we live in is built in 1908, and we moved in and learned what repointing meant. We needed all of the bricks to be redone on the outside, the mortar between the bricks, and a lot of other joys of owning an older house. We also, slumlords are a problem in DC. And when we think about that, we think about sort of the tiers of landlords. We see landlords who are basically okay and have some issues. We see medium landlords that don't do a great job with their properties and need to put more work into it. And then we see the worst of the worst who just are really not taking care of their properties at all and need to do a much, much better job. And we do run into a fair amount of those landlords in our properties. We also want to say out loud that systemic racism is a real issue that is a reason why a lot of our clients run into the housing that they run into. The historical legacy of redlining, of how loans were given out in the city for where properties are and how properties are maintained are a lot of the reasons why our clients are where they are in the city and why their housing is maintained the way it has been maintained in the city. And so that's a legacy that has marginalized a lot of the housing that our clients live in and where our clients live. And so it's not something that we can undo in any individual case, but it's something to have in the back of your mind as to why we have large tracts of housing that are much less well maintained than other parts of other housing in the city. When you look at places where nobody could get federal loans, or where we pushed a lot of our lowest income residents of the city, that's something to think about. Even if you look at who are renters in the city, in Ward 7 or 8, which are our lowest income parts of the city, 80% of people are renters, as opposed to the wealthier areas of the city where that statistic largely flips as to who are homeowners. Money. We can't underestimate money as a barrier to healthy housing. There's sort of two money motivations we see a lot of times as a barrier to healthy housing. One is just it's expensive to keep your housing up. So you can make a lot more money as a landlord in a property if you don't maintain the housing, right? You keep the money that you would have paid to maintain it from someone's rent, and you get to keep that as profit. So that's just sort of a basic manual. There's one particularly bad landlord who's actually published his own self-published manual. You can order it on Amazon about how to be a bad landlord, basically by keeping your tenants' money to not maintain the property. The other thing that I just want to talk about in DC, which we see a lot, is around gentrification and just making money in real estate, that people often in DC, because when you convey a property that has tenants in it, unless the owner is going to move into it themselves, the tenants convey with the property. So if you sell a property to a developer, the tenancy conveys with the property. And so the tenants get to stay there, which is great. It's very tenant friendly. And sometimes we see landlords who will allow the property to essentially disintegrate around the tenants' ears in the hopes that the tenants will move out and they can sell an empty property. And the last barrier is, unfortunately, what we think as a barrier is actually our tenant inspection agency, DCRA. It's the agency that's charged with housing code enforcement in the city, but we don't think that they're doing an adequate job of that. And as a result, we don't think that they are doing code enforcement effectively, and landlords are not afraid of them. They're not seeing them as someone that's going to help. Tenants don't see them as an agency that's going to help uphold healthy housing in the city. And so they're not actually helping in any way keep up healthy housing in the city. And if we had an effective code enforcement agency, we believe that that would help us have healthier housing in the city. Happy to talk more about that with anybody who's interested. We've certainly testified about it a lot, and you can pull that up on our website if you're interested further. I also want to talk about health equity and housing conditions, just to frame that as an issue for you. If you look at these two maps, the map on the right over here on this side, you can see these are number of families living below the poverty line. So Ward 3 up here is our wealthiest area of DC. And you can see there's almost no families below the poverty line. In Ward 7 and 8, this is the Anacostia River over here. Here's Ward 6. You can see there's a lot more families living below the poverty line. We have very high concentrations of poverty here. About 1 in 4, a little more than 1 in 4 kids lives in poverty in DC. Almost 1 in 2 kids lives in poverty in DC across the Anacostia River. You'll see some tracts of poverty here, randomly along here. That's actually where universities are. So we don't think so much about poor college students when we're thinking about healthy housing. But if we're looking at families in wards 5 and 4, there's also some concentrations of poverty. If we look at this other map, this is from Children's National Hospital, and we look at where there's asthma rate visits to the hospital, and that could be, these are emergency department visits, ED visits to the hospital, and you can see that that map largely overlays with poverty. In Ward 3, where there's a lot more trees and green grass, and also families who can often access medical care at a higher rate, but also where there's healthier housing, where people are not seeing as much unhealthy housing, which we see in our cases and we see in data. There's very few ED rate visits for asthma, where in Ward 7 and 8, where we see a very high incidence of unhealthy housing according to our cases and other data, we see a very high asthma rate. And that translates to about you're 27 times more likely to go to the hospital for your asthma if you're a child living in Ward 7 or 8 than if you are living in Ward 3. And the reason we focus so much on asthma, and you'll hear us talk about that a lot, is that asthma is something that's relatively straightforward to talk about in housing conditions. We know that kids with asthma have a very high correlation to allergies to mold and to pests. And we see a lot of kids coming in who say they're well controlled outside the home, in school, and in the community. They take their medication as prescribed, but when they get home, their asthma becomes exacerbated, that they can't breathe, that they end up in the hospital because they have roaches, they have uncontrolled mold, and their landlord's not doing anything about it. And CLC actually has done, we have a really fantastic evaluation team at CLC, and our case handling team, along with our evaluation team, has been able to do some research and has been able to show some correlation between our work and decreasing visits to the asthma to the hospital after we fix the housing conditions. And again, we can share more information about that if people are interested. This is a map that we did of our housing conditions cases that again can show maps pretty closely. Oops, I don't know what I just did. To the housing conditions cases, to the ED visits, and to poverty. So you can see a really high concentration. About 60% of our work overall is in Ward 7 and 8. And you can see that it also goes along the Georgia Avenue corridor up here, where there's a pretty high rate of gentrification, but also where we see a lot of ED visits. So again, these are our housing conditions cases, and poverty and asthma are all overlaying. And that's why this work is really important, because we are really trying to get into issues of health and racial equity by working on housing conditions cases with our clients. This is a study that Children's National did that they shared with us that looked at similar stuff. So it's not just our data, but their data looking at the rate of, this is self-reported by their patients, but looking at rates of poor asthma control and rates of unhealthy housing, again, showing similar things that Ward 7 and 8, and again, in these same areas, much higher rates of unhealthy housing and uncontrolled asthma are very highly correlated. Again, basically showing nothing here in the wealthier areas of DC, very low correlation, very high correlation. In the unhealthy housing. Nearly 25% of children with persistent asthma, which is one of the higher categorizations of asthma, lived in unhealthy housing. So why do we talk about this? As I mentioned, kids in our lowest income areas of DC are 20 times more likely to visit the emergency room for asthma. And the environmental triggers are there. Like, the research is there to show that the environmental triggers in the home trigger kids' asthma, as well as other health conditions can be correlated, but asthma is the one that we see most often in our cases. And we also get cases just where that don't need research, that we just know, like a baby shouldn't sleep in a crib where there's mice crawling through it. That just seems self-evident. Like, families shouldn't have to live like that. Or a child shouldn't come home. And, we've had a doctor come in and say, do you have any pets? And they're like, Mom, do the roaches on our walls count as my pets? And, just that's not how kids should have to live. And so even if they're not triggering their asthma in that moment, we know that that can be correlated to certainly other health issues. And we will come in and do a housing conditions case. What we find is that, as with other kinds of cases, the family may have been amazing advocates. They may have done what we have advised as the first steps of making their requests in writing and ask for everything. But sometimes they need you with that Esquire behind your name to come in to be able to get that change. And that's how we can use, our law degree to get change for families, that a lot of times landlords don't do much without it. And I think it's a real opportunity for us to go out there and make real change for clients that wouldn't be able to get this done without us. I'm going to also just talk to you about how we get our cases. So what is a medical legal partnership? This isn't just some random doctor in the middle. That's actually the doctor who started medical legal partnerships out of Boston Children's. It actually came from the pediatrician side. They got really frustrated from seeing these what are called social determinants of health, where they'd be in the medical context seeing patients come in and say, like, hey, I'm prescribing this medication, and insurance would be like, hey, we're not covering that. Or you lost your Medicaid. Or in a housing conditions context, I'm prescribing your asthma medication. I'm so glad you're taking it. It's too bad that your housing triggers your asthma all the time. And so they decided to add a lawyer to the team, and a lawyer to the team in the medical setting where patients are already there. So the patients are already in the community. There's over 300 medical legal partnerships at this point across the country. They're not all pediatric. Some are in cancer settings, some are for veterans. We at Children's Law Center have one of the oldest. We started in 2002 at Children's National. And the model is really great because it's in the community. we have lawyers that go to different community health centers, in our instance, all pediatric health centers, and the doctors or medical staff make referrals to us, and then we meet with the patients in the setting if we're there, or follow up with them afterwards. For those of you who are lawyers, which I think most of you are, it's probably not a shock to hear that that people don't always love lawyers. I know it's crazy to think, but we find that because their trusted pediatrician is making the referral, it lets us start like 10 steps into a case, because it's somebody who's saying, hey, you might not like lawyers all the time, but this is somebody you can trust. This is somebody who's going to help you solve that problem. And from our end, it lets us talk to doctors about, hey, this is a legal issue. This is something we can help with. Or these are some tips you can give families. These are red flags. We found that doctors didn't want to even ask questions because they didn't have a solution, right? Like, they might know that a kid shouldn't be sent home from school 3 days a week, as a favor to the family. Or they might know that a landlord shouldn't tell the family just to buy their own pest stuff, but they didn't have anybody to send them to, so they didn't really want to ask a lot of questions about it. And once we were there to train them and be a resource, they wanted to ask questions. They wanted to make that referral. And it also lets us be in the community where the clients are, so it's convenient for the clients, which we'd much rather be. We are partnered with Children's National Health System. I'm located at the Children in non-COVID times at the Children's Anacostia Clinic. Evan is partnered with Children's Generations, which is the teen parenting program. We're also at Children's at the Arc in Ward 7. We also partner with Children's Impact DC, which is their emergency room asthma program. We partner with Mary's Center for Maternal and Child Health at their Fort Totten location, at Unity Healthcare at their Upper Cardozo location next to Target, and at Unity Healthcare, Unity Minnesota Avenue. So we're at several healthcare locations throughout the city, all pediatric primary care centers. And we get referrals from them at Mary Center and Unity Upper Cardozo. It's a lot of Spanish speaking clients. So if you speak Spanish, and please let Alyssa and Jen know, or any other languages, but we get a lot of Spanish speaking referrals and would love to develop our base of Spanish speaking pro bono attorneys. Or if you speak Amharic, that's also awesome. And in terms of direct impact, in FY 2018, we served over 3,000 children and families, almost 60% from Ward 7 and 8, and these stats are almost the same for last year as well. We trained over 1,900 people. And then CLC is really, what we realized over the years is we do a lot of fantastic individual work, and we are using that individual work to change systemic stuff as well. We have a 5-person policy team. And through that work, we've done things like pass mold legislation in the city. We work a lot on mental health. We're trying to change the housing code system in DC, both inspections and improving the law around housing code. We do a lot of agency oversight and things like that. So that's kind of the overview of where we are. Oh, and then the type cases we handle. Housing conditions are a little over a third, and actually last year was even a little higher than that. Education's about half of our work, and then we handle other types of cases in the medical legal partnership. So guardianship, public benefits, Social Security, those types of cases, healthcare and mental health care. And then by ward, we get, like I said, about almost 60% of our cases are in Ward 7 and 8, and then you can see the breakdown from other wards. The stars are where our clinic sites are, so you can see where we're physically located throughout the city, as well as our main office. And these are the types of housing conditions we see. About 41% of our referrals have mold in them, 40% have mice or rats, 32% insects. I'm not going to read you this whole slide, you can read it, but significantly have mold, mice or rats in them. And if you combine mice, rats, and insects, about a significant number have infestation, and mold are probably the two biggest things we hear about. In winter, we get a lot of no heat cases where the heat is inadequate or just off, and we have to deal with those on an emergency basis. Jen talked about this a little, but I just want to really emphasize again, we can make a real difference for families where they just can't get this done on their own. And you as a lawyer will get a real chance to advocate for a family. You'll get Evan will talk about the experience of litigating in housing conditions court. You're not necessarily going to get a full-on trial experience, but you'll get a court experience, and you may get a chance to work with an expert depending on what kind of conditions case you take on. But you'll really get concrete results for kids and families, and really get some positive change made. So thanks again. And I hope that you guys all immediately sign up to take cases, and happy to take any questions now. At the end, I think, is when we're taking questions. So I'm going to turn it over to Evan if there's no urgent questions now.
Hi, everyone. So I'm going to talk a little bit more specifically about what housing looks like in DC, what the legal structure is for housing, who's a tenant in DC, and then what the housing code actually requires in DC. So we're going to get into the nitty-gritty now. The first is that, as Jen mentioned, there are a lot of acronyms and there's a lot of terms that get thrown around, and a lot of them are used somewhat interchangeably. So it helps to have a basic understanding of the vocabulary. When we talk about subsidized housing, that's a really unspecific word, and there's a lot of things fall under that umbrella. So we'll be talking more specifically, more definitely about what different types of subsidized housing exist in DC. When we talk about HUD, we're talking about the Federal Department of Housing. They oversee all federally funded housing, including in DC. And then DHS in DC is referring to the department that is overseeing the homelessness system, and that includes families in rapid rehousing, which is a program that helps families move out of homelessness. DCHA, or the Housing Authority in DC, this is kind of a quasi-federal, quasi-local agency that operates all of the public housing properties and also oversees the majority of vouchers in DC. DCHA and HUD will use what are called HQS, Housing Quality Standards, to review their properties. Housing quality standards are not the same as the DC Housing Code. So when we're talking about enforcing the housing code, making sure that homes are meeting the code, we are not talking about the housing quality standards. We're talking about what is actually in the DC law. Housing quality standards in some ways align and in some ways don't. So it's really important that, if DCHA says, well, we inspected this property and it meets our housing quality standards, that is not saying it necessarily meets the housing code in DC. So that's an important distinction to be aware of. And then, as Kathy mentioned briefly before, DCRA is the regulatory agency in DC that will do inspections of properties. So they are embedded with the Housing Conditions Court, which I will discuss, but they also are available for clients to just call and ask for an inspection of their property. We've had mixed experiences with them, but that is currently who is responsible for coming out and making sure that homes meet the housing code. So in DC, tenancy is a little less clear-cut. The good news is it's a very tenant-friendly jurisdiction. So, of course, families who have a formal lease are considered tenants in DC. Also, anyone who's paying money for a place to stay. So you might not actually have a written agreement, but you're paying an acquaintance so that you can stay in their basement. You are now a tenant and you're entitled to all the same protections as somebody who has a formal lease. In DC, there's also an automatic right to convert a lease that has expired to a month-to-month lease. So the termination of a lease term is not grounds for an eviction. The tenant automatically has the right to carry over and to turn that into a month-to-month lease. So very frequently, this is what we're finding in our cases. We'll ask, the tenant, do you have a lease? And they'll say, well, I signed something in 1992. I guess I don't have a lease anymore. They do. They're now in a month-to-month situation. It's automatically rolled over into a month-to-month tenancy. So we also find a few other more unique tenancy situations. When a building is foreclosed upon, the bank actually becomes the new landlord. And of course, banks hate this because banks don't want to be called when you have a plumbing issue or when you have rodents in your house. but in fact, that is who is now on the hook as the new landlord. So we do find those occasionally. And as I mentioned before, the end of your lease is not a reason for your tenancy to expire. There actually has to be a good cause for the termination of your lease. So that in DC is considered, you failed to pay your rent, you violated the terms of your lease, or the owner of the property actually wants to move in, and so that's a reason to displace you. But just the termination of a formal lease is not a reason for ending the tenancy. So there's a lot of different types of legal structures for housing in DC, and the type of housing that your client lives in will dictate what remedies are available to your client. So it's important that you have a basic understanding of the different types of housing in DC. So I'm going to run through those very quickly. So in private housing, this is where the tenant goes out on the private market. They find a property they want to live in. They enter into a lease agreement with the landlord, and they're paying with their money to the landlord in exchange for the tenancy. And this is kind of like the traditional private housing relationship. Nobody else is involved in that relationship. So the next type of housing that we see is called project-based Section 8. This is when people talk just broadly about affordable housing. This is frequently what they're talking about. So this is where there's a voucher that is attached to the actual property. So somebody goes out and they apply to enter into the property. They say, I'd like to live here. My income is X amount of dollars, and based on their income, they will pay a varying amount of rent. The remainder of the rent that they do not have to pay is actually going to be covered by HUD. So the tenant might be paying anywhere from $0 to full market rent for this property based on their income. If the tenant wants to move out of the property, they do not get to take the voucher with them. So if they've only had to pay $200 a month in rent because their income has been low, they cannot expect to have that same sort of arrangement at another property. The other important aspect of this is that you can't just transfer between properties. So even if Horning Brothers, that is one property owner that we see frequently for project-based Section 8. Let's say that's your landlord for your project-based property. Even if you'd really like to move to their other property that's across town, it's considered a separate entity altogether. So you don't have any transfer rights between those properties. The problem with this is that the wait list for these properties is quite long. So you might love to transfer from one Horning Brothers property to another, but they may say to you, well, you don't have any special rights to do that. You're just going to have to get on the wait list like everybody else. And so that can take quite some time. It also means that when families are just out there on the market trying to find these properties, they're having to go to each individual property on its own to do an application. There's no centralized wait list. So it's just kind of an onerous process for clients, and a lot of these properties, again, have very long wait lists. So the next type of housing is DCHA housing, also known as public housing. So this housing, I will say from the jump, is just very, very difficult to get into it. There's incredibly long wait lists, astoundingly long wait lists, so much so that DCHA actually closed the wait list 7 years ago. So they're using that time to purge the wait list, find out who's still alive, who still needs public housing, try to find the folks who are on, get the contact information for folks who are on the wait list. So actually getting into public housing at this time is very, very difficult. That being said, we still have a lot of clients who live in public housing or who have been living in public housing for a very long time. And some of these properties are in very, very poor shape. Because they do require major investments to bring them back up to code, and they just haven't been funded to do that. So we do find a good number of our cases are against DCHA for their public housing. So when a tenant is in public housing, there's going to be regular inspections by DCHA. Again, those inspections are going to be done according to the housing quality standards. They're not done by the housing code. These properties are kind of throughout the city. You may be surprised to find out that there's one near you. They're really spread out. The one good thing about being in public housing, well, there are many things, but one of the good things about being in public housing is that there are rights to transfer between properties for various reasons. So these are all outlined in the DCMR, but some of them include safety reasons. So there's community safety or domestic violence, for reasonable accommodations reasons. So if you have a disability that requires you to be in an accessible unit and you need to be able to move to another property that does have that accessibility, there's just more property and more housing stock within the public housing system, and there's an ability to be transferred from one property to the other. Now, that process is a bit opaque, and it is very hard to know how long those transfers take for our clients. They can be quite long. Clients can be waiting for a long period of time, and sometimes they have more choice than others about where they get transferred. So they may end up moving from a community that they've been in for a very long time and placed somewhere else with very little say. So there is some additional options in a public housing case if that is your situation. Certainly worth talking to your mentor about whether or not those factors come into play in your case strategy. So the next type of housing is the Housing Choice Voucher Program, HCVP, formerly known as Section 8 vouchers. So if you've heard of a Section 8 voucher, you've heard of HCVP. This is a kind of like the golden ticket. This is what people want because it allows you to go actually anywhere in the country and use this voucher so that you aren't paying any more than 30% of your income towards rent. It's a legal relationship between the tenant, the private landlord, and the public housing. So whatever portion of the rent, let's say the rent is $2,000, the tenant's only going to pay 30% of their income towards that. So let's say the tenant has to pay $500 a month. That remainder, that $1,500 would be covered by DCHA. So it's an ideal program in that it allows a lot of flexibility. Clients have a lot more choice about where they live. They can move in and out of DC. And one of the goals of the program is so that we're not concentrating pockets of poverty in one location as you might have with a very large housing development, but rather allowing families the choice to move wherever they might want. So this chart is helpful for just conceptualizing who oversees whom. In these cases, it can be a little bit tricky to figure out who's the landlord, who has responsibility here. Largely, if this is a project-based Section 8, you're going after the landlord, and the landlord's going to be a private company. But they are ultimately overseen by HUD because they're overseeing that funding structure. DCHA is going to be overseeing typical public housing and then different voucher programs as well. So this is just helpful to keep in mind who you might need to be talking to address the issues in your case. So let's get to the meat of what is a housing condition, what are we seeing in our cases, and how do we actually go about addressing those? So the issues that Kathy kind of talked about briefly that we're seeing a lot include infestations. We see a lot of infestations. And one of the problems we find with infestations, beyond the fact that they can be triggering for folks with asthma and other conditions, is that there's just insufficient remedies that landlords are taking to address these. So some landlords will say, okay, you've got a mouse hole in your wall. I'm just going to put some steel wool in there and it'll be good. They don't care. Rats will chew through steel wool. So that's not an appropriate repair. Or they will want to come in and do some big fogging treatment for insects. Well, that chemical treatment can be a huge irritant for kids breathing. So there are proper ways to address these infestations, and part of the role of a lawyer can be ensuring that the landlord's actually making the repairs in the proper way. We also see a large amount of mold. So mold requires a source of moisture, and a lot of the properties that we're seeing have very old roofs or very old plumbing. And so as a result, you've got leaking, you've got water coming in, and that can develop into mold behind the walls, in front of the walls, in the flooring, in the carpeting. So we see mold pretty frequently, and it's very concerning for, particularly with kids with breathing issues, but it's not healthy for anyone. As I mentioned, some of the repairs that we see are inadequate. We see a lot of cracks, holes, just old appliances, old fixtures that the landlord hasn't invested in repairing, electrical issues. These are just some of like the rampant things that we see over and over. And you'll kind of become familiar with what some of those things are just after, if you sit in housing conditions court and hear over and over, how many people have infestation issues, how many people have plumbing issues. It's very common across the city. So in our cases, we also encounter families in need of reasonable accommodations. So this is where somebody in the home has a disability that entitles them to an accommodation, whether that be a policy or an actual physical accommodation to ensure that their housing meets their needs. So one accommodation that we commonly see and ask for is carpet removal, because carpet can trap a lot of the allergens that can impact an individual's ability to breathe. We also encounter a fair amount of just inaccessibility. So making sure that the doorways are wide enough for somebody who uses a wheelchair, or that the family doesn't have 3 steps up to the entrance to their apartment for an individual who has mobility issues. So reasonable accommodations are kind of an ancillary issues that come up in a lot of our cases. Depending who the landlord is, they may have different requirements under the law on how they excuse me, on how they accommodate the family. So housing conditions, we've been hinting at the housing code. What is the housing code? The housing code is an actual portion of DCMR, Title 14. It outlines very specific requirements for properties in the city, what they must do in order to meet the code. So some things are as specific as the square footage required per person per sleeping room, what type of ventilation you need for a cooking surface, that you can't have moisture or water intruding into your home, that you have to have screens and your windows can't be broken. Some things that you would really expect and some things that are really detailed. And so it can be a very clear source for anyone who's doing this work. In addition to the DCMR, there's what's called the International Property Maintenance Code. This is really specific. There's the maintenance code for plumbing. There's a maintenance code for electrical. This is very detailed information about how each of those different types of systems in a home need to function. And for the large part, this has been adopted in DC. So one thing to know is just that if there is a conflict that arises between the housing code and the property maintenance code, the property maintenance code actually takes precedence. So you may remember this from property law, those of you who are lawyers on the call. There are some basic property rights that any tenant has. The first is, of course, the warranty of habitability, that tenants can't waive their right to live in a habitable location. That can't be waived in the lease. No one, should be living in unsafe or unsanitary conditions, just like the bare basics here. The other piece that is more contentious than you might think is that landlords must repair all the conditions in the home. So sometimes we hear, the tenant says, I have a plumbing issue, my toilet is not flushing. And the landlord comes out and says, well, it's not flushing because your kid put some Legos down it, so I'm not gonna fix it. That is actually not what the housing code requires. The housing code requires that the landlord repair the issue, and then we can talk about liability later. We can talk about who might be at fault and who might have to pay for it, but the actual repair needs to be done by the landlord or the landlord's agent. This is really important because of it's very hard to prove causality, and because our clients often cannot afford to pay up front to have repairs made. And they still have the right to live in safe and healthy housing in the meantime. So sometimes this is something we have to remind the courts of, but this is really essential that landlords are responsible for all repairs in the property. On the flip side, we also have to ensure that our clients are aware that they have to provide access for repair. So they can't have water flooding into their basement and then say, yeah, but landlord, I don't want you to come in and take care of that. They don't have the right to bar access to the owner. Landlords are also in particular required to take care of any safety issues or fire hazards in the home. So major issues that we see are smoke alarms not working, carbon monoxide detectors aren't available. I've had cases where the doors didn't fit properly into the door casing. So especially when it was hot, the door would swell and then the family couldn't get in and out of their home because the door would get stuck. Well, that's a major safety issue. What if there was a fire in that home and the family couldn't get in or out? So those things are emergency issues, and we would encourage you to flag those immediately to the landlord's counsel, or if necessary, filing an emergency motion with the court regarding those, because they are so severe and serious, and we do see them regularly. So in addition to the Housing Conditions Code, we are very happy and proud to have the mold law in DC. So the Children's Law Center was a key part of getting this law passed. This law provides really detailed instructions for how landlords have to go about addressing mold in the home. Before this, there wasn't a lot of clarity on how do we remediate mold, what is mold, but this spells it out very clearly, and it's one of the clearest points in the law that you can point to when you're doing these cases. So what does the law say? It says that tenants need to provide written notice to the landlord of suspected mold. The landlords have to then inspect for mold within 7 days. Then the landlords have to, if they find mold, they have to remediate it. And that when they find more than 10 square feet of mold, it has to be remediated by a licensed mold professional. So the law actually creates this licensing scheme of how do you become a licensed mold inspector? How do you become a mold remediation specialist? It creates that 10 square feet minimum for when a licensed mold remediator is required. So we have a clear metric of when your regular maintenance folks can come in and take care of the mold, and when you actually have to hire a licensed mold remediator. And then it actually establishes some penalties for landlords who don't follow through on these timelines and don't meet their responsibilities on the law. So we actually have a little bit more teeth with this law to hold landlords accountable. The law actually does some work in laying out what is mold. So that is very helpful and has been litigated as well. I'm happy to go into the details of that if you're so interested. But what is visible mold or visible by the naked eye, a mold inspector can actually come in and use tools that the layperson might not have, so they can take air sampling, send it away to a lab, compare what the air quality is inside a building versus the air quality outside the building. Mold is a naturally occurring substance, so you do find it just walking around outside on the street, but there shouldn't be a higher incidence of mold inside your home. And so they're able to compare the amount of mold outside versus inside. They're able to take surface samples, take a little scraping of the wall to test for what is on the wall. They're also able to use moisture detectors, so they can kind of look through the walls, if you were, to see if there's moisture behind the walls. And of course, we know moisture leads to mold, so that can be indicative of mold growth. So all these different things are spelled out inside the law. I really encourage you, if you have mold on one of your cases, to spend some time just reading through this portion of the law. It's not long, but it does provide really good teeth that you can sink your teeth into to address mold and to hold landlords accountable. I mentioned this a moment ago that there has to be written notice. So one thing that we do when we first get our cases, if they mention that there's mold, we really do try to establish, has the tenant contacted the landlord, and if so, how? A text message counts, an email counts, but we do like to see that the tenant has provided that written notice, and that they can show it to us so that we can prove that as well. We also like to see that they've actually done an inspection, that they just didn't send somebody over to rip out the walls, or what we see very often is to wipe down the walls and then paint over it. Painting over mold does not solve mold, but we see that regularly. So we want to make sure that the landlord is on notice of what the requirements are, and that the tenant is aware of their rights, so that they're not. I've had many tenants who've done a great job of saying, hey, now you can't come in and just start painting. Like that's not what's allowed here. And by making sure that the tenants are aware of their rights, they're able to really stop things from happening inappropriately at the door, which is super important when bringing your case to court. The 30 days is the timeline that's set in the law. So after there has been established that there is mold in the home, the landlord actually has to remediate that within 30 days. With the 10 square feet, so 10 square feet is, it's not a huge amount of space. It's, if you think of those old drop-down ceiling tiles, suspended ceilings, it's one of those. I mean, it's less than the standard door to your house. So it's not a huge amount of space. And when we're talking 10 square feet, we're talking about from a single source. So you could have 2 square feet in your bathroom from a leaking sink, and then you might have another 5 square feet in your kitchen. If those 2 sources of water are not the same, you don't have 10 square feet. You can't add them up if they don't come from the same water source. If they come from the same water source, you can. So that's really important as a distinction. The tenant also always has the right to get their own assessment. These are relatively spendy. Most tenants are not able to go out and pay for an inspection on their own. In theory, the court could order reimbursement for the assessment with the finding of a code violation. So if the landlord just refused to come out and do the mold inspection, the tenant could ask for reimbursement for the inspection. I haven't actually seen this happen, but it is clearly within the code that you could do this. Similarly, there is a provision for punitive damages if the landlord just is acting in bad faith and doesn't do what they're supposed to do under the mold law. Again, I haven't seen this actually done in court, but we would be very excited if you were interested in pursuing this and working with you to talk through the strategy, because I think it is something that should be used and is available to be used for our clients. So I'm going to pass this back over to Kathy, who's going to talk a little bit about like the nuts and bolts of how you handle these cases and how you work with our clients.
Hey everybody, I see one great question that popped up, and I'm going to get to the correct slide while I am doing that, about how we're documenting stuff during COVID, and I'm actually going to incorporate that into what I'm talking about next. But we are doing virtual inspections, and that's actually worked out really, really well. Our clients are able to take us through their house through FaceTime, or actually we're often sending them a Zoom link that they're able to click into, and then we're able to take pictures or doing they're also really great about taking videos and pictures and texting those to us. So that's been a really successful way to document the conditions. And I'll talk to you a little bit about that now as we talk about handling a case. Sorry, it jumped all the way back. It did not like me doing what I just did. Sorry to make you guys dizzy right now. There's no good way to fast forward through this as far as I can tell. Okay, here we go. Handling a housing conditions case. So some pandemic considerations will be incorporated into this. So first of all, legal issues impacting health issues, just as you go through that, as you're thinking about these cases. We know just from surveys and studies that have been done with low-income clients over the years, an average low-income resident has about between 3 and 5 civil legal issues facing them at any given moment. So just something to think about, and that I always like to keep in mind in working with our clients, like the housing issue in front of you is the legal issue in front of you right now, but it's just one of many legal issues and one of many issues going on with them in their lives. If you haven't read the book Scarcity, it really impacted just some of the vocabulary and ways I think about how I face my own life, but also the way our clients are thinking about their lives. And I use the term bandwidth a lot as a result. just, it's the way people's brains have only a certain amount of bandwidth to think about stuff. So housing is the issue that they prioritize, they've chosen to work with us on now, but there may be a lot of other things going on in their lives. And part of the next part of this presentation is about handling a case, but also thinking about just sensitizing us all and just saying out loud some of the stuff to be thinking about, and remembering as we work with our clients, going on that could be going on in their lives, and maybe other things to be thinking about. And it's not that we expect that you're going to work with them on it, but it may be things you want to come back and talk to your mentor about, or other resources that you may be able to make them aware in the community, to access as well. So our clients are, for the most part, quite low income, and that can mean that their jobs look a lot different than our jobs if they're working. A lot of our clients who are working are in jobs where they're not allowed to talk on the phone during the day. They may be able to text you, but they can't just pick up the phone. So, you know, I have clients who will be like, I'm talking right now, because they may pick up the phone when they see it's me, but they can't actually answer the phone at work. They might be able to text you though. They have clients who don't work because they need to care for disabled children, and it doesn't actually, they can't find a job that lets them work only during school hours, or right now during COVID, their kids are schooling virtually and they don't have the ability to work and have anybody watch their kids. And because of their income, they may be making some really hard decisions about what they're spending their income on. And that could include coming to see you. So one of the things we'll talk about is, you know, coming to you for initial client meetings, which isn't so much of an issue now. But in times, you know, if it does come to a time when clients could come to see you, whether it, you know, it means that they're able to come and see you or not, because it may be the, you know, the $8 for bus fare, because they have to pay for each bus that they take, is too much for them to get to you. In terms of education and literacy levels, and we'll talk about this a little bit more, a lot of our clients may have graduated high school, but a lot of times a high school diploma may mean that people are on an 8th grade reading level, or not, may not even be that high. And some of our clients may have even lower literacy levels. So we try to keep things at a pretty basic literacy level. I think for a lot of attorneys, that's one of the hardest things to unlearn, is to not talk and write like a lawyer. Law school drums that out of us as hard as we can, is to talk and write like a non-lawyer. And so I would suggest that you really think hard about how you're going to explain stuff and write stuff, so that it's not all legalese, that you're not using abbreviations and acronyms, and that you're really explaining it like you would explain it. How are you going to, because a lot of, especially law firm lawyers, your client, or, you know, my husband is a government lawyer and all his clients are lawyers. How do you explain it to a non-lawyer? Our clients rely on public transportation in COVID and non-COVID times, and it takes them a lot longer to get someplace. Like, it takes me 10 minutes to drive to the anacostia clinic from my house, but if I were taking public transportation, it would take me an hour and a half. So building that time in, if clients are getting places, just remembering it might take clients a lot longer to get someplace. In addition, barriers to communicating with you, I mentioned the inflexible job. So thinking about when they can schedule calls with you, when is a good time to call them, and what's the best method of communication. I want to mention email. Like, a lot of our clients have email addresses, which is fantastic, but a lot of my clients don't check their email unless I text them and tell them that I emailed them. I'm on email all day, every day. That's not the same email culture that a lot of my clients have. Text is often the easiest way to get clients. I recommend that you get a Google Voice number if you don't have one. I find that's just an easier way for me. Google Voice is a free number that you can get that gives you another number. I just have the app on my phone. It allows me to send it from a Gmail account or from the Google Voice app, which you can log into on your computer. You can log into it through the app on your phone, and it lets you have a phone number and a texting number where you can receive pictures, you can send texts, and it just masks your regular number. You can make calls from it so that you're not necessarily giving out your regular cell phone number. And you can kind of use it for pro bono cases if you want. Or if you have a work phone, you could give out that number. And then a lot of our clients are caring not only for their own children, but maybe other people's children. They're caring for other relatives, and so forth. And that can be a big time commitment. And then some of our clients still have have limited cell phone minutes. They may not have contracts that give them that go unlimited every month. They may just pay for a certain amount of minutes a month. So if someone's cell phone is off at the end of the month, you may find that it's on at the beginning of the next month and try again. And so you may want to just wait till the beginning of the next month to try again and see if you can get them. Our clients' cut phones often change numbers may change as a result of that also. And we'll talk about some strategies around that when we get to communication. I just want to point out what poverty actually is. So for a family of 4, if you make $26,000, if you make $26,201 in DC, you are no longer considered to be living in poverty. So earlier when I said that, 1 out of every 4 kids in DC lives in poverty, that means that their family of 4 makes $26,200 or less. There's a lot of kids in DC that live above the poverty line, but are still very low income, that are still struggling to make ends meet. And we don't have a hard income line at CLC because we know that there's a lot of families that make much more money than $26,200 for a family of 4 and still have a lot of trouble making ends meet in DC. And so, but as you read about poverty in DC, just keep in mind how low the poverty line really is and how much it takes to live in DC. When you take a housing conditions case I'm just going to go back. Sorry, one more second. For the communication and cell phone pieces of it. The one thing I also wanted to say, when you get the case, just make sure you're getting phone numbers of everybody that you can in the household. And we'll talk about that again in a minute. When you get the case from CLC, you receive all the information from everybody that we gather. You'll get a copy of our intake. Alyssa, who's on this call, will send everything to you. And you'll get everything you need for conflicts check. You won't get an email from the assigned mentor until you let us know that conflicts have cleared, because a lot of firms don't want further information. And so if you don't let us know conflicts have cleared, we'll ask if they've cleared. But once you let us know, you'll get an email within 1 or 2 days from your mentor that'll have a lot more information about like our initial thoughts on the case, some background, some suggestions for next steps, and we'll offer to set up a call with you. Evan and I are the main housing conditions mentors, so now you've met us virtually at least. I know for myself at least, please email me. That's the best way to reach me, much better than voicemail, especially in COVID times, and I'm happy to set up a call with you. We will notify the client that a pro bono attorney has been found, but we won't give them your information. We'll leave it to you to reach out to the client. We ask that you contact the client to schedule the initial client meeting. You'll see ICM in here as the abbreviation for that. But we, again, leave it to you to set up the initial client meeting. We'll ask you to ask them to update any updates from the landlord. We'll ask them that when we notify them, but who knows, something could have changed. We ask you to consider, any logistical challenges if you are meeting in person, which you probably won't be right now. In the pandemic, we've been doing all of our initial client meetings as virtual meetings. Should that lift or change, and you meet in the client's home, our practice is to meet in the client's home for housing conditions meetings. We do that. We do meet in the client's home. We do meet in the client's home for all of our housing conditions meetings. And that comes out of actually feedback from clients that they felt very strongly it was important that the attorney, and we go with an attorney and an investigator, attorney and family outreach worker. Many attorneys go with an attorney and a paralegal or 2 attorneys out so that you can document the conditions during that home. And as I mentioned, during the pandemic, we're doing those meetings virtually so that we can take pictures and see the conditions for ourselves and understand what's going on. And we think that's important also because a lot of times our clients they don't know the housing code. How would they? And so we're able sometimes to see violations of the housing code that they don't know and really get a sense of what's going on through those virtual or in-person meetings. I saw a question about what's going on in the housing conditions court, and we will cover that a little bit. The court is doing everything virtually. Right now. They are holding hearings, but they are virtual hearings. So we'll talk about that later. So the initial client meeting, the basics, you'll sign the retainer and release. We have a sample retainer in the materials. You're not required to use that retainer, but you should sign a retainer. And we have a sample release. You're not required to use that release, but we do recommend getting a release of information both for the client and their children, because you never know what information you're going to need during the case. You can talk about your mentor if you have questions. we do not recommend mailing the retainer, because we really recommend that as part of your role is to help clients work through some of the best practices. And that includes not signing things they don't understand. And there's almost no way a client's going to understand a retainer without you explaining it. So we recommend walking through the retainer and explaining what the retainer means and walking through the relationship with the lawyer. So I typically walk through and say, have you ever worked with a lawyer before? Often the answer is no, or maybe it's yes, but it was a criminal lawyer, maybe sort of. And so I'll say, okay, let me just explain what it means to work with me. You're the boss because you're the client. That means you're setting the goals for the case and you're setting the direction for the case. That means it's really important that I'm in contact with you. So if your phone number changes, I really need to know it. If I need to be able to be in contact with you because you're the boss of the case. I'm the lawyer, which means I really make some of the strategy decisions, like should we send the letter this day, or should we file this motion or that kind of motion? But you're the one making the decisions about, are we going to sue anybody, or are we going to send a letter or not send a letter to make these kinds of demands? I explain about confidentiality and privilege. I explain about like going through the retainer about, if there's a disagreement, what that between us, what that looks like, and so forth. Again, you want to use really simple language and not legalese. You want to discuss who's going to communicate with the landlord. Are you going to be the one communicating? Are they? Is it some combination of that? And be explicit about when you want them to contact you. Do you want them to contact you every time there's a problem? Do you want them to contact you if the landlord contacts you? How do you want to do that? Someone asked about how we are signing retainers right now. That's a fantastic question. So we have been slow to get it, but we finally have electronic document signing, and we are doing it that way. And I think it's fine to ask clients if they're comfortable with that, and that would be my first choice because I think you'll actually get it back. We've also been mailing retainers back and forth with clients, so going over it with them by phone and mailing it back and forth is a fine way to do it. But I think if you can get it, one way also is to mail it and have them take a picture of it and send it like by photo back to you. That may be an even, if you mail it, send it with a stamped envelope so they can actually mail it back with you. I wouldn't count on our clients to have any stamps to mail them back to you. Stamps, so send a stamped envelope. You may want to have them send it as a picture and stamped. The post office has been really slow. Ward 7 and 8 post offices are really understaffed due to COVID, so it's sometimes taken as much as like a month to mail stuff back and forth. So I think electronic document signing, you might want to really walk them through how to do it, like be on the phone with them when they're signing it. So if there's anything difficult about it, some of our clients have no trouble with that. Some have had trouble with it. But I think if you're firm or you have access, we just got a free program. Jen, I don't know if we're sharing that with pro bonos, but I think it would be a great idea to share that with them as a resource if they need it. So we can share that information if you need it. And then going back to this, be explicit about when you want them to contact you. Any contact from the landlord. That's our recommendation, is like any contact with the landlord. I think it's a fine line about who communicates with the landlord. Like you don't want to, my recommendation is during the case, like you're making the big requests about repairs, but as the case tapers down, you might want them to start taking it over because you're not going to be their attorney for life. So you want to help them build a relationship with the landlord if they're going to stay on the property. But during the case, you may want to manage some of that because, like, at least for the big stuff, but you probably want them to be calling in. You want them to have the power to call in some of the stall stuff because you don't want them to call you every single time they see they need anything. You want them to report it to the property manager. It kind of depends how intense the litigation is. I think it's a little bit of a game time decision. But at the very least, you want to know about if they're calling it in. So if they've made a repair request, so you could have them text you about it. It kind of depends on the case, but just flagging for you, it's something to think about. Pandemic considerations, like we talked about, the initial client meeting will likely be virtual, capturing screenshots, getting documents signed virtually. The other thing to really think about that's come up interestingly during is, does your client want repairs? It's something we'll have screened about, but a lot of our clients want some of the big stuff, may want some of the big stuff repaired, but they may not want somebody in to repair everything. Because remember, it may be different repair people for different things. So they may have a major leak, a ceiling caving in. They absolutely want that repaired, but they may decide they don't want like something minor dealt with, because that would be a different repair person, and they may not want to take the COVID risk of having like 10 different repair people in their house. Or it may be that they're going to get put up in a hotel because it's such a major repair, and then they want somebody to just come in and deal with everything. It's just something to talk through about that. And what, like, we've been adding into our demand letters that all people coming in to do repairs need to be masked. They need to like what kind of COVID precautions are you going to ask for? If they're not going to be in a hotel, we've been asking for notice so that our client can have their children out of the house, like, or our client can be out of the house, that they're setting the minimal number of repair people, our clients wanting to be masked. Like, what kinds of COVID precautions are you asking for to ensure that that it's safe for the client during the repairs? And how do you want to counsel about that? And some of our, and then we've also been getting pushback from some landlords who are saying illegal things like, we're only doing emergency repairs, which are very narrowly repaired. That's not what the housing code says right now. There's no amendment to the housing code. They have to make the repairs, but just think about during COVID, what do repairs look like during COVID, I think, is a question, because some people have been thinking about what they want. And here's some of those tips. If you do go to a hotel, think about like I just had a client had to go to a hotel this weekend. We requested a room that nobody had stayed in for 3 days, and that there's a kitchen in it, because our client didn't want to have to go to deal with restaurants or takeout, so that they could be self-contained with their family in the room. So thinking about, again, COVID precautions during this period, how can you make it as safe as possible if they do have to be out of their unit? And maybe you're requesting a hotel in a time when you might not otherwise, if there's going to be a lot of people coming in and out for the repairs because of that kind of exposure. Because like in prior times, maybe they could have gone someplace during the day while repairs are made, and now there's really they can't just go to a family member's house. Like, there might not be a safe place for them to go during the day. Maybe they do need a 24-hour hotel stay to be able to have the repairs safely made. So it's something to think about as you're going through, how do we COVID safe do these repairs? Okay, so we do sometimes have clients who are tough to stay in contact with. And I think some clients, like I mentioned before, life happens, and the housing conditions case is a real priority for them, right? Like, our clients sought us out, they were referred, they went through our whole intake process, right? Like, they want this to happen. It is a priority for them. Their children's health is a priority for them. But like with any of us, like, it's a priority, but sometimes other things happen. And so it's important, and their cell phone number might change. And like, as lovely as I'm sure we all are as people, we are not their family. We might not be the first person they think to tell us that their cell phone number changed. So I do recommend that you get a couple different ways of getting into contact with them. If they only have a cell phone number, could they give you another person's cell phone number just in case their number changes? Or do they check their email? Or what's the best way to get in touch with them? Don't forget about snail mail as a way to get in touch with them. You know where they live. It's a housing case, so you could always mail a letter as a last resort. If you don't, our clients actually often do respond to the letters we send of like, hey, haven't been able to get in touch with you, call me. And they're like, oh yeah, so sorry. So that is another way to always get in touch with people. But we recommend at the beginning, just think about what's a contact plan. Like, hey, if your number does happen to change, what's a good way to get in touch with you? You may want to set up a regular schedule for contact. Like, I'm going to call you every Wednesday morning based on your work schedule. I'm going to call you every other Wednesday, or just I'm going to text you every Wednesday to check in. So they're expecting it, and then they remember. You may not need to do that, but that may be something you want to do. And like I said, if you lose contact, you could send a letter. We recommend written communication at an 8th grade level or below. You can actually check that in Word. It's a function after you do spell check. You can turn that on to check the communication level. And again, don't mail the retainer. Explain it to the client. I talked a little bit about explaining the client as the boss. We really do that to address the imbalance of power, because you as the attorney do hold a lot of the power in the room. We recommend that you explain confidentiality, use layman's terms, and that we recommend you end the initial client meeting and actually a lot of subsequent meetings with a written to-do list for you and your client, so that you're all on the same page of like, this is what I'm going to do at the end of this meeting. This is what you're going to do. And I think of it as like the end of a doctor's visit. Like, I usually leave my doctor's office totally clear on what medications they prescribed and what they were for. And then I get home and I was like, I have no idea what they told me. And so if I didn't write it down, then I would have no idea of what I was supposed to do or what new medications I was like, what they told me. And so I think it's really important for us to, again, model that and do that and come up with clear stuff. And it also avoids some miscommunication with you and your client. So often what I'll do if I'm not there in person to do it is I will follow up with an email or text saying like, here's what we said we were going to, our next steps were. And it also just helps you think of sort of the case plan of your case of like, here's how we're going to move things along. And if you're not quite ready at the end of the meeting to come up with it, you can always say, all right, I'll follow up and text you or email you with what those next steps are. And the next steps may be as simple as like, you're going to let me know if your landlord calls you, or you're going to let me know if the landlord, makes a repair, but just something, because it also keeps your client kind of in the game. After the initial client meeting, you'll document the problems or request any reports and figure out if you need any experts. Just to flag here, you would be responsible for hiring any experts to bear the cost of those experts. Who's the landlord? You're going to look at the lease and check the landlord. I'm going to start moving quickly because we revamped this training and we're running close on time. You're going to look at the lease. You can check Property Quest here. The landlord has the ultimate legal responsibility and provides the funds for repairs. So usually we put the owner and the property manager on there. Sometimes the property manager has like the contractual responsibility to go to court, but ultimately the landlord's the one who we litigate against. Then we usually send a demand letter because the demand letter, like even if the client has asked for it, because we're a lawyer, often they'll do the repairs when we do send the demand letter. But sometimes if there's a lot of notice or if they've made really bad repairs, we may choose not to send the demand letter. And that's because, we may choose not to send the demand letter. And I'm gonna turn it over to Evan at this point to complete the last little bit of the training and take us through the last couple of slides. Sorry, I went over what I was supposed to do. Sorry, Evan.
Okay, everyone, I'm just going to run through quickly some of the legal options that might be available to you in your case. So you could reach out to DCRA and request an inspection short of going to court. This can work right now. They're doing all their inspections remotely. So I really advise using this option only if there's kind of an emergency issue. They are still sending some folks out in person. So if you have a real emergency issue, like there's sewage flooding into the basement, this is still a worthwhile direction to go. The pros and cons, I would say the pro would be that you can actually get an inspection, get eyes on this, but sometimes you don't want to wait to get in front of a judge. So again, if it's an emergency issue, sometimes you can get the inspector to come out right away. You're not even gonna have to wait for court. If it's a lot of more minor issues, sometimes it's not worth having DCRA come out and then you're just gonna have to file in court anyway, because the landlord's probably not gonna respond to it. So I don't always recommend this. Right now, I primarily recommend a DCRA inspection if you have an emergency issue and that you think, if we have documentation of it, we're gonna get the landlord to move quickly. Again, as we talked before, DCHA and HUD have their own standards for doing inspections. So you could ask if it's a DCHA property or a voucher property to have HUD or DCHA come out and do an inspection. However, because they aren't using the housing conditions code, they're using their own housing quality standards, that might not be the most effective route. It also can create an issue where if let's say it's a voucher, if the landlord fails the DCHA inspection twice, they could pull the voucher and then the family has to move. So you might have actually created a bigger problem for the family. So I don't usually take this route. I don't think it typically achieves the goals that our clients want, which is usually to remain where they are, but to get the repairs made that they need. As we talked about before, if there's a disability in the family that needs to be accommodated either through a policy or a physical change, you can submit a reasonable accommodations request. Talk to your mentor about how to do this and where it's available. For DCHA, there's a form just on their website that you can submit and help your client submit. There's also some considerations here about who the landlord is, if it's something that the landlord just has to allow the tenant to do, but the tenant's going to actually be financially on the hook for it, versus whether the landlord actually has to pay for it. So that distinction is really critical, particularly for our clients who may have difficulty paying for the accommodation. So it's worth talking to your mentor about these situations before you make the request. Where it's a public housing property, the reasonable accommodations request, as we talked about before, could involve removing carpet or an actual transfer. There's really helpful joint statement out there from DOJ about the Fair Housing Act and reasonable accommodations. And it's really helpful because it answers a lot of frequently asked questions like, who pays for carpet removal? In what instances could the tenant be on the hook for carpet removal? So I really encourage you, if this comes up, to Google that joint statement and just take a look about what's in there. It's in very plain language and can be really helpful to walk you through this. So lastly, but probably one of the most important pieces of this training, court. So court is available and we're lawyers, so we do go to court. In theory, these cases could go to a variety of courts. They could go to the landlord-tenant court, they could go on the civil docket, small claims. But in DC, we have a separate docket that's specifically for tenants to file cases against their landlords to repair the conditions in their unit. And so that's the calendar that we are primarily practicing in and that you would primarily be filing in with these cases. So I'm just talking a little bit about what that looks like and what it looks like during the pandemic. It is a civil court, and it is a court in which the judge primarily treats it as a settlement court. You're really suing for repairs. The judge is not interested in talking about rent payments, not interested in talking about lease violations, not interested in getting reimbursement for private property that was damaged, if the flood ruined your client's couch, that sort of thing. They're not going to deal with it in this court. The only thing that this judge occasionally will grant is prospective rent abatement. So, it's been 6 months and there's been a really horrible mold this whole time, and the landlord just hasn't felt interested in making the repairs necessary. The judge may say, okay, you know what? Today is July 28th. Tenant, don't pay your August rent. I'll see you back here on August 20th and we'll talk about whether you're going to pay your September rent or not. So they'll do that prospective rent abatement, but he won't discuss whether the last 6 months you should have been paying or not. That is something that you would have to bring a small claims case for. So just prospective rent abatement and then repairs are really the only two things that get discussed in this court. To file in housing conditions court, it's really set up as a pro se court. So there's a pretty simple form that you can use to file the complaint and the summons. You can also do an addendum to those forms if you want to explain a little bit more about what's been going on or provide pictures. My experience is that the judge reads what's filed, but is also very dependent on what the court inspector herself sees, and so may or may not want to spend a lot of time delving into what you've mentioned in the complaint. TROs are available in this area of law. So for an emergency issue, that would be like sewage coming into the home in the winter, no heat. The AC is broken and we're in the middle of a horrible heat wave. Really emergency issues, you can file a TRO. Those are being handled by the judge in chambers. And they could, in theory, have a same day hearing anywhere. And some days we see a hearing that doesn't happen for another week. So the practice really varies on how those are handled, but you can do a TRO for these cases. There's no form for those, so you would need to just draft your own, but we are happy to provide samples if you are interested in that. Most of our clients qualify for our fee waiver, the IFP form. These cases are fairly reasonably priced if they don't qualify. I would say the majority of cases you'd be getting through Children's Law Center, they will be eligible for that, and that form is also available on our website and on DC Superior Court's website. Typically, you would file these cases in person at the civil clerk's window. That's a little bit different now. So now these cases can be filed by emailing the civil clerk. Just yesterday, I received emails from another pro bono attorney who was having trouble with this. I think the distinction is if there's not an IFP that's attached to your pleading, they are sometimes bouncing these and asking you to still file them in person by just dropping them off in the Dropbox at DC Superior Court. All that is to say, this is a moving target, and so you should try filing via email at first, and you may get different instructions just based on what's going on with the courts and the particulars of your filing. So I would start with the emails. It's certainly the easiest route to start with, and then you may get other instructions. So I talked about briefly when you might want to file a TRO or a preliminary injunction. We are doing these right now this time of year primarily for major flooding issues, displacement issues, or no AC. So housing conditions court, how it works, it's a Tuesday morning court. Right now it's Tuesday all day because they're trying to do it remotely. You file a case, and in typical times you would get a hearing about 3 to 4 weeks later at an initial hearing. At the initial hearing, you'll need to show that you served the landlord. You should take care of this yourself. In theory, if there's an IFP, the court is going to attempt this, but they really make one attempt and then kind of give up. So I really recommend that as an attorney on the case that you go through your own process of making sure the landlord has been filed or has been served, and then you file the affidavit with the court prior to the initial hearing. One kind of tip is that a lot of these landlords are represented by the same cast of characters that are also representing them in landlord-tenant court. And it's a pretty small world of attorneys that represent these landlords. So you can often just search the landlord on the DC Superior Court website, see who pops up as their attorney, and then email that attorney and say, hey, do you represent them in housing conditions cases? Would you accept service for this housing conditions complaint? And sometimes they're willing to do that. So that is one practice tip. Once you've served them and you have your initial court date, we recommend bringing your client with you for a couple of reasons. One, I think it just humanizes the family that's involved, what they're going through, but also logistically, it's much easier just to have them there for scheduling. The court typically at the initial hearing ensures that service has happened, that the landlord accepts service, and then we'll schedule a housing conditions inspection. So there is a DCRA inspector right now, it's Christine Hall, who is embedded with the court. So what that means is she is doing all the DCRA inspections for the court, and then during court on Tuesday, she's always present there to discuss what she saw and what she's recommending. So you will be scheduling, most likely you'll be scheduling an initial inspection at the initial hearing. It's helpful to have your client there just for scheduling purposes more than anything. Sometimes you'll get the landlord to agree to certain repairs. This court does not issue orders, so don't be expecting one. If you really do want an order of something specific, I recommend having something prepared for the judge just to sign because they are not used to drafting up their own orders. All these hearings right now are happening remotely. So there is one set of instructions to call in every week. I think it's the same number. So you could, if you're interested, just observe as well because they're open to the public. They're happening over WebEx. The court inspector is there and they're happening very much like they would happen in person. I don't know of any date by which the court plans to go back to in-person hearings. Right now, they are fairly backlogged because they didn't have hearings for several months. So you can expect that each Tuesday they're quite full. The dockets are quite full. They are one saving graces. They are scheduling things for on the hour at different hours. So you might have a hearing at 1 p.m. rather than everyone having to show up at 9:30 and sit all morning long waiting for your hearing. So that is one small blessing. In terms of initial hearings right now, initial hearings, we've been filing, but we haven't seen any new initial hearings actually taking place. So I think that is a matter of just a backlog that's happening right now. But I know one of the questions was, how does that affect strategy? Generally, my recommendation would still be to file in a case because it puts the landlord on notice and also sometimes we see landlords get serious about making repairs once they've seen something filed in court. They don't want to have to appear before the judge. And wouldn't it be great that you filed, you served the landlord, they made the repairs, and then you got to dismiss the case before you even had an initial hearing? That's what we really all want. So sometimes we do see that impacting our cases right now. Typically, after the initial hearing, you're going to have a status hearing and a series of status hearings. These typically take place about a month or so after your initial hearing. And then at each status hearing, you're just going over the report from the inspector, talking about what repairs have been made, what repairs still need to be made, any barriers to those repairs being made. And those can just continue to go on for months. I would say most housing conditions cases resolve in about 6 to 9 months, though we do see occasionally cases that last over a year in court. Ways to kind of move this forward. So again, the judge is not issuing a lot of orders. This is really not an evidentiary court. It's not a trial court. The judge is very reluctant to do those things. However, you can try to push the judge on those. You can ask for an evidentiary hearing. Let's say you have 2 mold inspection reports that have contrary indications about what needs to be done. Maybe one says there's more than 10 square feet of mold and the other says there's less than 10 square feet of mold. You know, that really comes down to who does the judge credit as an expert witness. And so you may want to ask for an evidentiary hearing if you can't work it out. Judge will really push you to work it out, but there is room to ask for that evidentiary hearing. So you may be hiring experts who are mold experts. We've had pest control experts. We've had, I think we had a fire expert. So we've had a variety of people who can come in and actually speak to the repairs, because this judge is very quick to say like, well, you know, I'm no pest expert, or I'm no electrician. So it is helpful to say, you know, neither am I, but here, you know, I have somebody here who's prepared to talk to the court about why these repairs are necessary and why they're critical. So I think you'll have to push the court to move in a direction that's not merely a settlement court, but it is possible. And so that is kind of the quick overview of how to handle a housing conditions case. We do have a number of pro bono cases that are available to take, and so I'm going to hand it back over to Jen Massey, who's just going to discuss what's available.
Thank you so much, Evan. Thank you, Kathy, as well, and everyone for joining us today, whether you're here with us live or on demand. We do have several cases available. Clients are reaching out to us looking for repairs as we're facing the pandemic and folks are in their homes even more than usual. These conditions that may be impacting the family's day-to-day and health, it's all the more important to have repairs made. So we're happy to stay after for those of you joining live, and I'll turn off the recording. For those of you watching on demand, please don't hesitate to reach out and send along any questions or interest in a case so that we can chat. As the pandemic continues to unfold in terms of what the remote representation looks like, what the court docket is looking like, please don't hesitate to reach out. Whatever changes are happening, we're monitoring and we're mentoring around them. So thank you again for thinking of us at CLC, and don't hesitate to reach out with questions as you have them.